Chapter 53. Disorderly House. Section 705. Definition. The keeping of a disorderly house, that is, one kept so as to disturb, scandalize or annoy the community, or persons passing in its vicinity, is indictable at common law. If the building is open to the public, as an inn, there may be an indictment for disorder which affects only those of the public who go inside, and does not annoy anyone outside. However, the disorder must affect the public in some manner, and offend persons other than the dwellers in the house. A disorderly house has also been defined as a house in which illegal practices are carried on habitually, or to which people resort promiscuously for immoral purposes. This latter definition embraces not only disorderly houses proper, but what were known at common law as bawdy houses, indictable as such, that is, houses kept to receive persons who choose to go to it for illicit sexual intercourse, and also tippling houses, kept for promiscuous noisy tippling, or where unlawful sales of liquor are made to all who desire it. A licensed drinking place may become a nuisance because of the disorderly manner in which it is conducted, thus annoying others, though the acts done are not themselves unlawful. So a house may be disorderly, merely because disorderly characters resort there, although the public is not affected. Conduct on Sunday which would not be disorderly on a weekday may render a house disorderly. It has been held that the keeper of a place where the law against usury is habitually violated, is guilty of keeping a disorderly house, but this holding is contrary to the best authority. Section 706. Bawdy houses, or houses of ill fame. To constitute a bawdy house, other women than its keeper must resort to it for immoral purposes, but it makes no difference whether the disorderly conduct is perceptible from the outside. It is not necessary that the reputation of the house be bad, neither can one be convicted merely because the house has a bad reputation. The essential element is the keeping of the house as a bawdy house, and neither its reputation, nor general annoyance to the public. There must be evidence of more than one act of illicit intercourse in the house. It has been held that one may be convicted of keeping a bawdy house because his wife and daughter engage in lewd conduct without his dissent, although the contrary is also held. A house of assignation, where parties meet for illicit intercourse, though none of them live there, is held a bawdy house. One distinction to be remembered is that no disorder perceptible from without need be shown to convict of keeping a bawdy house, and no acts of public prostitution are necessary to convict one of keeping a disorderly house. Section 707. What is a house and who a keeper? It is sufficient to show the use of a single room in a house for illegal purposes under the charge of keeping a disorderly house, and a woman lodger having one room may be convicted of keeping a house of ill fame. The term house implies any building kept for immoral purposes, even a boat, or tent, have been held to fall within the definition. All who take part in carrying on and directing the business of a disorderly house are indictable as keepers. One who merely resides in the house is not so indictable, nor, it is generally held, one who merely lets it, but if the owner who lets it has knowledge of the intent to use it for immoral purposes, convictions of keeping have been upheld against him. Section 708. Letting house of ill fame, or procuring or encouraging its keeping. Letting or hiring a house knowing it is to be used for prostitution is indictable at common law, 30 as well as under various statutes. But a landlord without control who was ignorant when letting of the use purposed, is not liable. Anyone procuring, encouraging, aiding or abetting the keeping of a disorderly house is guilty as a principle.